Um, so I'll give you just a quick rundown of what this case is about, what the holding really essentially said on Monday, what the main arguments that we put forth in our amicus brief were, why this case is quite significant, and also we can end with, I guess, some discussion about mobilization tactics moving forward using this case. So this case, very briefly, was filed by a group of abortion providers in the state of Pennsylvania, challenging their long-standing state policy, which bans Medicaid funding for abortion in the state. And the challenge is based on, among other things, the state's Equal Rights Amendment, which was added to the state constitution in 1971. So quite an old constitution, state ERA, and unfortunately one that's gone underutilized because of this particular Supreme Court case in the state that has now been overturned. So the opinion, so this case was filed in the advocates filed it in 2019. So this case has been kicking around for a really long time. We filed our amicus brief. We joined in 2021. So it's been many years, and wonderful to see like a win and a positive result. And I would say this case is a big win for the ERA. The Supreme Court in Pennsylvania decided to rule that abortion access is unequivocally a sex discrimination issue, which is not the opinion of the current Supreme Court or even pre-Dobbs either, and that it necessarily triggers the application of the state ERA. Essentially, this case overrules old precedent from 1985, a case called Fisher, which basically took the teeth out of their state ERA. You know, the Pennsylvania has a good equal protection clause. There are other equality provisions, but I think when it was passed, advocates on the ground really wanted to bring a vision for it to advance reproductive rights. So 1985, there's a similar case challenging the state ban on Medicaid coverage for abortion. And that Supreme Court said that the coverage ban for abortion access is not actually an abortion rights issue. And this is following the logic of Roe, saying abortion has to do with the fact that abortion has to do with a person's right to privacy and right to choose whether to have an abortion or not, right? The government cannot unduly burden that person's choice. Now, in the case of funding, which is a little different, the logic is, well, the government then also doesn't really have an obligation to remove obstacles to access to abortion, not of their own making. So creating a real distinction, a line in the sand, sort of saying, we think that a person's economic status or indigency is not a sex equality issue, it's an economic issue, which doesn't get heightened or strict scrutiny analysis. And also under Roe, and goes to a critique of Roe, you know, the government can't unduly burden somebody's right to abortion, but they can express a preference through public policy making to sort of say, well, we prefer childcare or child giving, right? And so we can pass laws that prefer it without crossing over the line of burdening your right. So that's been the critique of Roe. I mean, that it was put abortion rights on the defensive from the day that it was passed in the Supreme Court. It's because it's rooted in privacy, it also puts that conversation and that burden of childbirth and reproductive health care and pregnancy and everything exclusively on the pregnant person. So the conversation gets very skewed. It's just about the woman or the pregnant person. It doesn't involve a larger conversation about everybody involved in procreation and family planning and birth and pregnancy. So in our amicus brief, which was filed in 2021, and you know, remember this is pre-Dobbs, so we are first need to set the baseline of like reproductive rights is a sex equality issue, and rooting it in privacy has a lot of weaknesses, which a lot of feminists at the time of Roe openly critiqued, but it was kind of like the best tool that we had in the moment. But certainly rooting the reproductive right and bodily autonomy to equality makes it a stronger argument because it has to do with what it means to be a full citizen in this democracy. That without bodily autonomy, without the essential choice, everything else that has to do with your access as a citizen in this country is compromised. That has to do with your education, your ability to work, your ability to earn income and accumulate wealth and participate in the democracy, right? That's all compromised. So you're not really a full citizen without this basic fundamental right. And so from an equality perspective, you need that. Otherwise, we're not a democracy. The other thing to think about is, and maybe this is kind of like the frontier of the Equal Rights Amendment, is it's all well and good to add language to the Constitution that says equality rights can't be denied or abridged. That's a principle. And how it gets delivered is it has to do with making sure that there's an equal pipeline of resources to people to make the right real on the ground. And you see with abortion access and with also funding for abortion that this question really comes to the surface, because you can have a state with really beautiful pro-reproductive rights, but if low resource people, rural people, and poor people do not have access to those rights, then they're essentially denied the right to bodily autonomy and reproductive rights. So who has the obligation? The state. The state has the obligation to really think through, how do you make these rights real so that they're not just like existing on paper. So in that regard, it is an obstacle that the state has a duty to remove. It's not just about money, and it implicates women, and it's a gender justice issue, right? Even if you're making an argument under Gedaldig or under Dobbs that, well, there are trans men who can get pregnant now, so that's why it's not a sex equality issue. Well, it has to do with your sexuality. It doesn't matter who the pregnant person is. Your reproduction is a feature of sexuality, so it's a sex discrimination issue under the ERA. So those are some of the things that we really advanced in our amicus brief. We really tried to provide the Pennsylvania Supreme Court with a roadmap to get there. The other thing that I'm I guess particularly proud of highlighting in our amicus brief is to really highlight the gender stereotyping issue, which I think because we thought we all relied on Roe, people haven't really given that much attention, and I think we really need to at this point, which is that somebody's reproduction, their pregnancy, their role in childcare, childbirth, that there are certain, I guess, stereotypes that would violate the ERA flowing from your role in the reproduction cycle. And so the other thing that we said, and it was actually cited in the opinion, which is great, which is that the ERA, beyond just pure equality issues, meaning Medicaid would cover reproductive healthcare across the spectrum for men, but excludes abortion, right? And that's not equal. That's a pure equality argument. That's, we can all get behind that. But also, what are the stereotypes that are attached to pregnancy and childbirth and abortion that the state continues to perpetuate? And having something like a coverage ban perpetuates these stereotypes, and that would also violate the ERA. So that's another argument that we made that I think the court really accepted and embraced. So what does this mean? I think it's really exciting. This is the first state Supreme Court case post Dobbs that is a positive ruling on the ERA and abortion. So this shows that there's a lot of momentum around the ERA. There's a sea change. It means that this is a really big, we all know this is a really big organizing principle that we can all get behind and then think through what tactics can be used to help give this opinion some legs. One idea to think about is that, there are already 7 states. Whether a state wants to use state funding to fund abortion is up to the state. They could do whatever they want, which is great. So there are currently 17 states that actually do fund abortion in their states. With ERAs, no wait, there are 17 states that fund abortions. 13 of them have state ERAs, undisputed. 4 of them have are in the process of passing ERAs, including Minnesota and also New York. And so this is a really good opportunity to reach out to all sorts of elected officials that are pro-abortion, pro-talking about the ERA, connecting the equality argument to reproductive rights, and getting them to issue some kind of public statement saying, we really support this holding in Pennsylvania. We think that the ERA, and we think that abortion is unequivocally a sex discrimination issue that's under the protection of the ERA. And, we want to, really pursue positive measures to make sure that this right is actually delivered to everyone equally. So, that's something that we can do and pursue at the state level. I will just kind of pause there. I know that was a lot of information. If people have questions, happy to
Yeah, of
answer them.
course. So Alice Kitchen has her hand up, so we'll start with Alice.
Yeah. Where does the Hyde Amendment fit into this? I thought it forbade any public funding to abortion.
It limits federal funding to be used to fund abortion, except in those limited circumstances where the life of the pregnant person is at risk. But she has to be like dying, not just like a huge health risk. And then also in the case of you know, rape and incest, but where you would need like a police report, which then makes it impossible for any to file. So that's federal funding. But in these states can use their state public funding to fund abortion, and 17 states do, and more can.
Thank you. Nicole and then Bobby.
Hi, Nicole. I saw you at the Women's E-News.
Sorry, how are you?
It was great. I saw you at the Women's E-News Gala where Nicole was honored. And I got to listen to her awesome speech.
Thank you. I was thrilled to see this decision and grateful for your hard work on bringing this. Columbia's brief was awesome. My reading of this, though, is that it provides an opportunity for federal leverage as well, in the sense that the Fisher decision is kind of akin to the Geduldig kind of reasoning.
Exactly.
And by overturning Fisher with an equal rights amendment, it leads to the conclusion that had the equal rights amendment been in the federal constitution, Dobbs may not have happened. Okay, I just wanted to see if you were on the same page, because that's kind of the tact I'm taking as far as publication goes. But thank you.
Yeah, I mean, I've been so kind of like steeped in kind of state ERAs right now and just thinking exclusively about like, well, what can other states do? How can they get on the bandwagon here? But yeah, certainly there's some tactics that can be employed at the federal level. I mean, we know we have a lot of great supporters in Congress. Maybe they want to issue a public statement that's like really succinct, so it's not too complicated, because I think Geduldig just makes everyone's brains explode. But
right. But people oftentimes pointed to Geduldig as the reason why you shouldn't publish. Well, the Supreme Court's just gonna, rely on Geduldig. And I think with the actual language in there, in the Constitution, assuming that the opponents of the ERA can even get past standing, which they probably will, given the way the courts use standing these days, we got a better shot.
Yeah, Geduldig doesn't make sense. So
right.
To the extent that courts, especially Supreme Courts at the state level, are starting to kind of turn their backs on it and to sort of say like, what is this? This is a weird Rubik's Cube that men created so that pregnant women don't get acknowledged under their constitutions. If we can create that kind of sea change too, like doctrinally, I think that would be really exciting. And it's starting with Pennsylvania.
Right. Thank you.
Yeah, and to that point, Ting, I think that what would be great, and I'm not putting it just in your lap, as just what I'm seeing from some of the people that have been emailing me back and forth, is if there's any way for us to kind of draw those connections to how the Pennsylvania Supreme Court case could apply or be used as a talking point in the federal ERA. I mean, I feel like the response I've seen go back and forth, just like, go into traditional kind of, some of the lawyers I've seen have been like, wow, this is only state ERAs and this, and everyone's like, not, the general public's not going to understand that at all. So like, if there are ways that we can find to more simplify the language, especially as we're coming up into the electoral season / trying to pressure legislators to move forward with this legislation, just so that advocates who maybe don't, well, first of all, even if we all understood that it's too much, it's just too much, But just if there's a way to simplify that in a way that's digestible so that when we're talking to legislators, when we're talking to potential candidates, that we're saying something that is accurate, but also something that people can understand. I think that I'm hearing that desire
Yeah,
you know, because
I
again,
think
like
that's a really great idea.
you know what I mean? So I mean, maybe just something to think about afterwards, because you know, I just think that we need to, I think a lot of people are going to be using this in terms of the ERA, which is federal in the election cycle when talking to legislators, but we just need to make sure that what we're saying is legally sound so that we don't get people saying, oh, these advocates have no idea what they're talking about. So just
Yeah,
coming up with how to translate that would be fantastic.
I think it's a great idea. I mean, and yeah, we can all kind of get together and have like a little working group to talk about it. I mean, to me, it just feels so basic, and maybe that's why we just need to hit the basic points over the head, which is like
Mhm.
everybody has a sex. You know, everybody has reproductive capacity, and therefore, this is a sex equality issue. And the ERA is necessary. I don't know, like there's something like very basic about all of this that I think throughout the years and through pushback and through the Supreme Court, it's become extremely complicated doctrinally. It's become
Yeah.
like a puzzle, but maybe that's like a tactic for people in power to confuse people, and then nobody feels like they can even understand the issue anymore, right? That was Dobbs. Like that kind of analysis is too complicated for people when really it has to do with millions of lives and their bodies. But
Yeah.
I didn't really feel that when I read the decision.
Oh, yeah. Yeah. But I think
But
that
yeah, let's
yeah,
talk.
that would be great. But there are also 4 more hands raised, so I'm going to try to get to them all, and then we'll just try to in the last like 2 or 3 minutes of, because I know we're almost at 2, try to just go through the discharge petition list. We're only like 14 members away from getting the number, and we feel like we need to do this sooner rather than later, just thinking about the likelihood of anything happening. So I'm gonna put on till 1:57 the questions, and then the last 2 minutes just ask that we go through the discharge petition list and see if we can brainstorm or if people can take assignments. But Bobby, Carolyn, Eileen, and then Jean. And so if everyone can make their questions fast, then we can get to everyone. Starting with you, Bobby.
Great. And Jan Erickson called me Monday late in the day to tell me about this. And it's very rare that Jan and I have a talk that's uplifting, a conversation that's uplifting, as
Yes.
opposed to, oh my God, another thing fell off a roof and hit us on the head. But anyway, brava. Thank you all so much who have worked on this. And I endorse the idea of a working group, or at least a meeting to follow up for those who want to go into this in more detail, because I have things I'm going to say in a minute could take a lot more discussion too. One is that I think after Jan called me, I emailed Linda Wharton, who's a friend who's worked on a lot of with the Women's Law Project. She even did some consulting for them on this case, and one of her law articles was used in a brief or in the decision cited. But in any case, I have had the idea, I mean, Jan and I have talked about the idea that we might, AJ, are you out there listening? I'm joking. Through the state law audit project, or at least this could be a spinoff perhaps, talk to people in the states with state ERAs who might be in a position to bring cases like this in their states. And then really go on the offensive with this. This is, as I say, it takes a lot more discussion. But I think that the coalition could play a really important role in networking around this idea with the states that have state ERAs. And it may or may not have some connection with the state law audit project. So that's for discussion. Linda Wharton sends greetings to AJ, she said, because she thinks all of this is a good idea too. And the other thing I just want to emphasize, I say this every opportunity I get, but Rebecca DeWolf's concept of gendered citizenship. If this doesn't if that concept of gendered citizenship doesn't have some bearing on this, I would be very surprised. I think we could talk about that too. And if I'm not mistaken, just Geduldig had the phrase, they said it wasn't sex discrimination because they weren't doing it against women. They were having a category of pregnant persons. Was that in Geduldig, if anybody knows? But in any case, I speak for myself, laugh, pregnant persons, what does that mean? Well, now we know what it means. And it's very interesting to think of how that phrase in the Supreme Court decision might be applied differently now that we have a fuller sense of who can become pregnant.
Geduldig is, I'm just going to try to explain a nonsensical thing. The reasoning underneath Geduldig is just basically that although this is wrong, because only women can be pregnant and men can't, it's not a sex discrimination issue because you're not treating the two genders differently.
Right, but right now I'm saying
My mind
yeah,
exploding.
right.
But
Yeah,
now,
we've come to an
we're in a different
understanding
landscape.
now that that's not literally true.
Just talking about kind of talking points and kind of like mobilization, sort of like organizing principles around this issue. And I see that somebody also just reached out to me to talk more about like international law. So, my background's in international law. I think a lot about kind of international human rights. When I talk to my people out in different, in the past, it used to be that Latin American countries with very restrictive abortion rights were looking to America for help. Like they're like leaning on us to help them expand reproductive rights. And now it's the opposite. Now I feel like we're looking at Latin American countries, especially Latin American countries, some of which have really liberalized abortion, and also countries that are extremely religious too. So they've worked it out. And if you study the global trend, there's a trending toward liberalization, meaning most countries, very religious ones, really restrictive ones, have been now opening up and creating expansive reproductive rights access. And this is through different pathways. So it could be decriminalization in Brazil, or through a Supreme Court case in Mexico, or through referendums in Ireland, or through legislation, or through constitutional change. So for America, we have to use constitutional change because everything else is so messed up. Our politicians don't care about creating real policies, except for Carolyn Maloney. Like they just want to consolidate power, right? And so we can't rely on kind of legislating to help women and help pregnancy and abortion and reproductive autonomy. And so we have to go straight to the Constitution, which is why this process is like much more truncated. But one thing to learn from kind of these movements abroad is that it's always been some kind of legal campaign and then a huge grassroots effort. And without it, none of the change would have been possible. And so one thing to think about too, why our work is so important, is that this is the grassroots effort that backs up the legal work, and it's necessary.